More breaking news out of the United States Supreme Court in the United States versus Rahimi case, that major case involving the constitutionality of 18 U.S.C. 922 G8, dealing with domestic violence restraining orders. Specifically, we now have approximately 37 amicus briefs have been submitted, either in support of the government or in support of neither side, which basically is a euphemism as I see it for supporting the government. That's just my take. Basically, we have approximately 37 pro-gun control briefs that have now been submitted in the U.S. Supreme Court. We will see the pro-Second Amendment brief submitted in about a month, but for now, we're only going to have a look at those that basically support gun control law, and we're going to talk about these in just 1 second. Stay tuned. I'm going to give you a quick summary of what I'm seeing already in my quick review of these briefs. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, a discussion of how the anti-gunners will take our gun rights away, their strategies from everything from the financial sector to red flag laws and beyond. Check it out if you haven't already purchased a copy of First They Came for the Gun Owners. Okay, folks. So approximately 37 amicus briefs have been submitted in support of the government or in support of neither side. Mostly that's because they support the government, although they may not want to say so. These amicus briefs I've taken a quick look at. I'm going to really break them down in extreme detail. We're going to talk a lot about these. I'll show you the strategies of the anti-gunners in great detail. And I'll give you my proposal about how they should be rebutted in 30 days when the pro-Second Amendment community gets to submit their briefs in the Rahimi case. Now, as you know, as a general matter, this Rahimi case is a potentially problematic case for the Second Amendment community because the Second Amendment community tends to be very responsible, very law-abiding, well-behaved, and based on all the allegations and what appears to have been the record down below, the plaintiff here, or I should say the individual here that's involved with the Second Amendment case, is this guy named Zaki Rahimi, who apparently, based on the allegations, the record seems to have done some really bad, violent stuff. Nevertheless, we understand the old axiom that says bad facts make bad law. We'll see if the Supreme Court will fall victim to that or not. We will see soon enough. But nevertheless, I want to tell you what I'm seeing from my quick skim of the 37 amicus briefs in support of the government. There's approximately 8 or 9 trends I'm seeing already. I'm sure I'll break it down in greater detail, but I want to flag what I'm seeing. The first one, of course, is what I've been predicting for over a year, which is the anti-gunners have very few historical analog gun control laws at the time of the founding in 1791 when the Bill of Rights was adopted, including the Second Amendment. So what are they doing? So, of course, they're going to do exactly what I predicted in my article in the Harvard Journal of Law and Public Policy, which is all the gun controllers are going to be talking about late 19th century laws after the Civil War, because there's a lot more gun control laws at that time. Of course, a lot of them are directed against the former Confederate soldiers and against blacks. They're motivated by race and religious animosity, things of this nature. So the bottom line is that those analogs should not justify any restrictions on the Second Amendment because they come far too late in time. Keep in mind that the Second Amendment was adopted in 1791. By the time you get to the years after the Civil War in the late 19th century, all the founding fathers have already passed away. They've already died. And as a consequence, any understanding of the Second Amendment of the late 19th century Americans would not speak to what the 1791 understanding was because, again, the people in 1791 had already passed from the scene. So we'll see what the Supreme Court does on that, but that's one big argument we're seeing already by the anti-gunners in the Rahimi case. No shock there. The second thing is, strangely enough, they brought back an argument called Corpus Linguistics. I haven't tried to torture you with this, and I'm not going to torture you with an article I wrote that's over 100 pages long for the Drake Law Review explaining why the doctrine of corpus linguistics is not a basis to restrict Second Amendment rights, nor is it any reason to consider in the context of the Second Amendment at all. In short, corpus linguistics is 2 words. Corpus means the body. Linguistics means language. It simply is the Latin phrase for a body of words. Basically, the doctrine of corpus linguistics says we're going to count up all the different words, all the different uses of a particular type of word at the time of the founding. And in the context of the Second Amendment, the argument goes like this. They say the vast majority of times that the word militia or arms or the to bear arms comes up is in the context of the military usage, which means they say that based on corpus linguistics, the Second Amendment does not protect an individual right to keep and bear arms. Instead, it protects a militia right or a military right, which of course is no right at all, because when you're in the military, you have duties but not rights. Nevertheless, that is the doctrine of corpus linguistics, but do not worry about this. This argument was raised in the Bruen case, and I'm proud to say that my article was cited to the U.S. Supreme Court, and the U.S. Supreme Court basically blew off the notion of corpus linguistics being a basis for restricting our fundamental right to keep and bear arms. So a major victory there. I don't see the Supreme Court changing course. Nevertheless, I'm seeing anti-gun organizations are using corpus linguistics again in the Rahimi case to try to gain ground on our rights. The third thing I'm seeing is a typical appeal to emotion. There's a lot of discussions, a lot of anecdotes about people that have been, of course, seriously injured or killed in the context of domestic violence. Obviously, these are all tragic stories, but again, we don't measure or define rights of Americans by virtue of how people may misuse the rights or people may misbehave. The fact that some psychopath shoots up a school in Nashville, Tennessee, is not a basis for me to lose my rights. That's not how we look at it, and the Supreme Court has repeatedly said this. Again, this is consistent with the notion of Cesar Beccari that says obviously people can misuse fire, they can misuse water, all sorts of bad things can happen with those, but that is not a basis to ban fire or water. So too with guns. But again, we're seeing a lot of stories, a lot of anecdotes, a lot of appeal to emotion about how guns have been misused. But again, anything misused, including cars, and we're not going to ban cars anytime soon. On a related note, in addition to those appeals to authority, we're seeing a lot of encouragement to the Supreme Court on these briefs, trying to get them to balance away our rights. Again, they're trying to get the court back into what's known as the tiers of scrutiny analysis, where courts get to balance the good versus the bad of guns. We never want to be in that world because the government courts, the government judges will always balance away our rights, because we know this because that's exactly what happened between the years 2008 when Heller was decided and 2022 when Bruen was decided. A lot of the lower courts did this balancing act to balance away our rights because they always was some government interest that they felt they could uphold and justify gun control laws. But again, we should not be losing our rights because of a government interest. In fact, our rights are there to thwart government from taking them away. The next interesting thing I saw in these briefs, there's a lot of reliance here upon proposals to the U.S. Constitution. There was different language that was discussed by the Anti-Federalists and by the Federalists talking about what should the Second Amendment look like. There was various proposals, different types of language. But again, none of these proposals are particularly relevant because the U.S. Supreme Court has repeatedly said that proposals made during ratifying conventions or the Constitutional Convention, these proposals that never became enforceable in law, really are dubious history at best, because again, they were talked about and never adopted. So again, it'd be like, hey, we talked about this potential term of a contract, it never got into the contract. So what exactly role does that have in defining the terms of a contract, because it never made it in, because the parties never agreed to it? Same thing with these proposals about the right to keep and bear arms that the anti-gunners seem to want to discuss to try to limit our right to bear arms. But again, the Supreme Court has already said if there's a proposal that never made it into the Second Amendment or the Bill of Rights, why should we talk about it? It's kind of irrelevant because, again, it wasn't agreed to. The other interesting thing I'm noticing that's quite interesting is the number of briefs that simply refuse to set forth the text, history, and tradition standard that Bruen set forth. Remember, Heller set forth the test of, you look at the text first, the burden shifts to the government to come forth with the history and tradition of restrictions. That was basically the Heller test. But because the lower courts kept screwing it up, the Bruen test really did a paint-by-numbers arrangement, saying you start with the text, then you go to history, and then tradition, which can be confirmatory in nature. But what's interesting, as you know, there's very specific language that the Supreme Court articulated in Bruen laying all this out. And I'm surprised by the number of briefs by these organizations that support gun control that simply do not lay that standard out. It's almost as if they want to pretend it doesn't exist. I can assure you that the U.S. Supreme Court knows it exists, and it will find its way into the opinion. In light of that, I don't quite understand why these anti-gun groups are pretending it doesn't exist, as if it's somehow going to go away if they don't pay attention or talk about it. That is clearly not going to happen. The Supreme Court are not morons. You can agree with them or disagree with them, but they're not dumb. And there's no way that the standard they set forth in Bruen is not going to find its way into the opinion. Nevertheless, these anti-gun briefs, a lot of them pretend that standard doesn't exist. They won't quote it. They don't talk about it. And I think that's a strategic mistake for them, which means it's very good for the Second Amendment community, because if I were on the court and I read a brief that did not talk about the actual binding operative standard, I'd be like, what's wrong with these people? Are they morons? So that's how I would view it if I were on the court. So every one of these briefs that don't talk about the standard, I actually think that's a point for us, because I think the Supreme Court will take that brief less seriously than they would have otherwise if they applied the standard and tried to get it right from their point of view. But if you blow off the standard, it frankly, I think, hurts your credibility with the court. I think the other thing that's kind of surprising to me is there's this distinction going on between substantive law and due process. Specifically, there's a discussion of what exactly does the scope of the Second Amendment entail, which is a substantive law. Remember, you have substantive law, which is like, what is the meaning of a contract? What is negligence? What is the Second Amendment mean? What does the First Amendment mean? These are substantive legal rights. They are substantive. This is a little bit different, of course, different than what are known as process. So, for example, you may have a substantive law that says this is what murder consists of, that you actively, intentionally kill someone and they die. That would be an example of murder. But there's a process by which you are tried. Specifically, that's what due process is about. It's very interesting how some of these briefs are trying to draw that distinction to say that as long as you're given adequate due process, you can lose your right to keep and bear arms. Not all of them talk about due process, but it is very interesting that this court could very easily have to talk not just about the substantive Second Amendment rights, but also about the due process that has to be put into place before someone can lose their right to keep and bear arms, in the same way that there's a process by which you have to follow before, for example, you go to prison and the burden of proof is satisfied by the government that you indeed, for example, committed a crime and thus can be sentenced and go to jail. That is the process. It's a trial. There's a jury. There's jury instructions. They have to be clear and so on. So I think one of the things we should be looking for in this case is what will the Supreme Court do in terms of the substantive Second Amendment rights versus the process by which you can potentially take someone's Second Amendment rights away because, let's say, they misbehave, they commit a heinous crime, or whatever it is. That distinction and that interplay will be quite interesting as we go forward. All right, folks, I know there was a lot to talk about today. There's going to be a lot more about this case that we're going to discuss. We're going to get very geeky. I wanted to give you a broad brush view as to how things are going right now and to what I'm seeing. But in the meantime, if you haven't subscribed to the Four Boxes Diner, please do so. We're trying to get our numbers up, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.